So, good afternoon everyone, especially to our professor, John Albert Lino. This is the Group 7 and this is our presentation. Employees' Compensation is State Insurance Fund, Chapter 1, Policy and Definition. So, Article 172, Policy. The state shall promote and develop a tax-exempt employees' compensation program which hereby employees and their dependents in the event of work-connected disability or death may promptly secure adequate income, benefits, and medical or related benefits. So, certain religious groups qualify for Social Security tax exemption if they are recognized as being facially opposed to Social Security benefits. Tulad po ng mga nag-retired na, yung mga person with disabilities are granted a tax exemption at yung mga namatay po. Yung kagandahan nga lang po dun, yung mga benefits po nila is meron po silang discount, halimbawa pag bumili po sila sa mall or mga gamot po. Article 173, Definition of Terms, Code Commission, SSS. Yung SSS for Social Security System is to provide private employees and their families protection against disability, sickness, old age, and yan. So, yung SSS po, ito po ay binabawas po sa sahod ng mga employees from the current 12% up to 13%. Shared by employer, 8.50% and employees naman po is 4.50%. So, yung GSIS naman po or Government Service Insurance System, it is an compensation package na po siya for both public and private employees. So, yung mga benefits po dito is yung medical services, appliances and supplies, rehabilitation services. Kapag namatay naman po yung employees, is makakatanggap po siya ng funeral benefits. So, yung employer po is include providing safe system of work, safe equipment and training for handling risk, monitoring health and safety at work. So, yung employee naman po is, halimbawa kapag namatay po yung halimbawa po teacher or sundalo is covered na po siya ng GSIS and SSS. While naman po yung dependents, it is an legitimate, legally adopted or tunay po na anak ng namat or sila po ay makakatanggap ng benepisyo under the selected health insurance plan. Yung beneficiaries naman po, sila legitimate din po sila na anak or asawa na makaka-receive din po sila ng mga benepisyo from a member retirement plan or kapag namatay po yung asawa niya. So, yung injury, sickness, death, disabilities, compensation, income benefits, medical benefits, related benefits, appliances, supply, hospital, and physician. So, halos magkakapareho naman din po sila na mabibigyan or makakatanggap ng compensation package kapag work-related po yung dahilan ng mga nararamdaman nila. So, quarter 3 consecutive months ending on the last day of March, June, September, and December. So, yung quarter po is 3-month period on a company's financial calendar that acts as basis of periodic financial reports. Halimbawa po, January, February, and March. So, yung replacement ratio naman po is gross income after retirement po and gross income before retirement and i-multiply po siya sa 100. Tapos dun mo po malalaman yung pinagkaiba. So yung credit year of services naman po, period of services determine the amount of benefits payable to a member. Then yung monthly income benefits naman po, halimbawa po kung 15,000 monthly yung sasahurin mo, so per pay period po is makakatanggap ka ng 7.5, then yung 15,000 po is ita-times mo siya sa 12 and divide po siya sa 365 days. So dun mo po malalaman yung kung magkano yung per hour mo is yung per hour po dun is 61.64 pesos. Injury. For the injury and the resulting disability or death to be compensable, the injury must be result of accident arising on the course of employment. So yung employer po is required to report injuries that their workers suffer while on the job. So kapag na-injured po, mahalaga po na mag-file agad ng compensation claim para po mabigyan or ng lunas po yung employee na na-injured. Sickness. Aside from injury or accident, the other cause that gives rise to compensation claim is sickness, which defined in Article 167 of the Code. So, yung injury po or sickness is maaari po silang di pumasok for at least 4 days lang po. Pag lumagpas na po sila dun is hindi na po yun sagot ng company. So, ibig sabihin po is magiging absent na po sila dun. Then, yung daily sickness allowance po nila is equivalent of 90% po. So, cancer po, ito po yung halimbawa po kapag nagtatrabaho ka po, tapos halimbawa pa sa pabrika, tapos dun ka po mismo yung nakuha yung sakit mo na which is asthma. So, pananagutan po yun ng company. Mabibigyan ka po nila ng medical benefits po. Tulad po ng tita ko, nagtatrabaho po siya abroad. Then, doon din nagkasakit po siya sa puso. Then, pinagamot po siya doon. Pero yung nagbayad po ng mga bills is yung amo niya po. Kahit ni piso po, walang binayaran yung tita ko doon. Chapter 2, Coverage and Liability. So, Article 174, Compulsory Coverage. Coverage in the state insurance fund shall be compulsory upon all employers and employees not over 60 years of age. So, yung compulsory coverage or compulsory insurance, it is mandatory po na dapat binibigay sa mga manggagawa or workers. Halimbawa na lamang dito ay yung mga retired workers tulad ng mga teachers. So, ayon po sa Republic Act 7641, makakakuha po sila or makakatanggap din po sila ng retirement pay. So, kasama po sa compulsory coverage, yung mga na-aksidenteng manggagawa po, sila din po ay makakatanggap galing po sa employer nila ng kabayaran or tulong para po makarecover sa aksidente. So, Article 175, Foreign Employment, the Commission shall ensure adequate coverage of Filipino employers employed abroad subject to regulation it may prescribe. So, yung foreign worker po, or tinatawag din po silang guest worker, halimbawa po yung mga OFW or Overseas Filipino Workers, sinisigurado po muna ng commission na sila po ay magkakaroon ng trabaho abroad bago umalis po ng Pinas. So, magkaiba po doon yung migrant workers kasi po yung migrant workers is wala pa po silang specific na job abroad. So, Article 176, Effective Date of Coverage, Compulsory Coverage of the Employers during the effectively of this title shall take effect on the first day of his operation and that all the employee on the date of his employment. So, calculated using hire date and the company's waiting period. So, kapag nung August 27 po na-hired yung worker, so yung company po ay mag-aantay pa po ng first day of the month after 30 days. So, 30 days from August 27 is September 27 and the first day of the month following is October 1. So, yung effective date is October 1 po. So, Article 177, Registration. Each employee and employer shall register with the system in accordance with its regulation. Article 177 of Executive Number 209, otherwise known as the Family Code of the Philippines. So, ang gustong pa rin magpakasal ng babae at lalaki ay hindi sila pipigilan ng kanilang magulang. Bukod lang sa kung sila po ay minor or below 18 is disqualified po sila doon. So, Article 178, Limitation of Liability. The state insurance fund shall be liable for compensation to the employees or their dependents, except that disability or death was occasioned by the employee's intoxication. So, bibigyan ka po ng tulong ng insurance kung yung nangyari sa yung aksidente is part pa din po yun dahil sa pagtatrabaho mo. Pero kung yung aksidenteng nangyari po is dahil sa nakainom ka habang nagmamaneho, is hindi na po yun sagutin ng insurance nyo. So, Article 179, Extent of Liability. The liability of state insurance found under this title shall be exclusive in place of other liabilities of the employer to the employees. So, yung employee po ay makakatanggap ng kaukulang bayad pag mayroon po sa kanilang nangyari. Halimbawa po is na-aksidente sila habang po nagdi-deliver ng mga produkto, which is po is job-related pa po yun. So, Article 180, Liability of Third Party. When the disability or death is caused by circumstances creating a legal liability against a third party, the disabled employee shall be paid by the system under this title. So, halimbawa po dito is nag-separate ka po sa employer mo and then nakapag-cause ka po ng accident. So, it is not available po against employee, supervisor, or co-workers. Instead of this third party liability may arise sa other common situation. So, hindi na po yun pananagutan ng employer mo kung nakabangga ka po or naka-aksidente ka po ng ibang tao. Kasi po is pumunta ka po dun sa lugar na yun na hindi ka po inuutusan ng employer mo and hindi na po yun sakop ng pagtatrabaho nyo. So, Article 181, Deprivation of Benefits. Except and otherwise provided under this title, no contract, regulation, or device whatsoever shall operate to deprive the employee or his dependents of any part of the income, benefits, and medical.
Employees Compensation Commission or ECC is government agency mandated to implement the Employees Compensation Program or ECP. This is a program that provides additional benefits and service to all Filipino workers who fall ill, have an accident, or die due to work. The ECC is a government corporation and it is the attached agency of the Department of Labor and Employment for policy coordination and guidance. The SSS is the administering agency of ECP in the private sector, while the GSIS is in the public sector. Most of our employees think that ECC, SSS, and GSIS are just one. Most people don't know that they are different and the benefits and services that can be obtained from ECP are in addition to SSS and GSIS. ECC was formed in 1975 through the Employees Compensation and State Insurance Funds. During ECC's 4 decades of service, it has helped approximately 6 million employees. Despite of this, many of our employees still do not know the ECC. Some of the mandates of ECC is to make policies and programs to effectively implement the ECP and analyze all the EC claims that are no longer approved in SSS and GSIS. ECC is actually one of the social security institution of our government, along with SSS, GSIS, Pag-ibig, and PhilHealth. The only difference between ECC and the aforementioned government agencies is that we employees do not pay or deducted for this, because it is the responsibility of our employers to pay our EC premium contribution. Powers and duties. The Commission shall have the following powers and duties: to access and fix a rate of contribution from all employers, to determine the rate of contribution payable by an employers whose record shows a high frequency of birth accidents or occupational disease due to failure by the said employer to observe adequate, to approve rules and regulations governing the processing of claims and the settlement of dispute arising therefrom as prescribed by the system. Next is to establish policies and programs for adequate occupational health and safety and accident prevention in the workplace. Rehabilitation other than that provided under Act 190, now 196, of the House of Representatives and other related programs and activities, and to appropriate funds for these policies and programs. To acquire property, real or personal, which may be necessary or expedient for the attainment of purposes of this title. Next is to enter into agreements or contracts for such services and aid as may be needed for the proper, efficient, and stable administration of the program. To perform such other acts as it may deem appropriate for the attainment of the purposes of the Commission and proper enforcement of the provision of this title. Management of funds. The Commission SSS and GSIS may disburse each year not more than 12% of contribution and investment earnings collected for operational expenses, including occupational health and safety program, incidental to carry out this title. All revenues collected by the system under this title shall be deposited, invested, administered, and disbursed in the same manner and under the same condition, requirements, and safeguards as provided by the Republic Act numbered 1161. Investment of funds. All revenues not needed to meet current operational expenses under this title shall be accumulated in a fund to be known as the State Insurance Funds, which shall be used exclusively for payment of the benefits under this title, and no amount thereof shall be used for any other purposes, notwithstanding any provision of existing law to the contrary. All funds accruing to the State Insurance Fund, which is hereby established in the SSS and GSIS, shall be deposited with the proper care and consideration for the system's liquidity needs. Settlement of claims. Any dispute arising under this title with respect to coverage, entitlement to benefit, collection, and payment of contribution and penalty thereon, or any other matter related thereto shall be resolved by the system, subject to appeal to the Commission, which shall decide appealed cases with 20 working days of the evidence being submitted. Review. Decisions, orders, or resolutions of the Commission may be reviewed on certiorari by the Supreme Court on the question of law upon petition of an aggrieved party within 10 days from notice thereof. The Commission's decision can be reviewed by the Supreme Court on the question of the law upon petition from aggrieved parties. Enforcement of decision. The Commission of Standards and Privilege has the power to issue orders and decisions, which become final and executory if no appeal is taken therefrom within 10 days from notice. Award granted by the Commission in cases appealed from decision of the system shall be effective within 15 days.
Chapter 4 Contributions. Article 189 Employer's Contribution. A. Under such a regulation as the system may prescribe beginning as of the last day of the month, when an employee's compulsory coverage takes effect, and every month thereafter during his employment, his employer shall prepare to remit to the system a contribution equivalent to 1% of his monthly salary credit. Based on my understanding, ang ibibigay na contributions ng employer o mareremit sa kanya ay 1% para sa employee niya tuwing last day of the month. B. The rate of contribution shall be reviewed periodically and subject to the limitations herein provided and may be revised as the experience and risk, cost of administration, and actual or anticipated as well as unexpected losses may require. Ibig sabihin, dito naman, yung rate ng contribution, chine-check periodically, depende sa experience ng risk at kung gaano kalaking kita ng company or sahod mismo ng isang employee. C. Contributions under this title shall be paid in their entirety by the employer and any contract or device for the deduction of any portion thereof from the wages or salaries of the employee shall be null and void. Dito naman, yung ang buong contribution ni employer ang magbabayad kay employee, pero then kung may deduction na ikakaltas si employee, di na siya makakount. When a covered employee dies, becomes disabled, or is separated from employment, his employer's obligation to pay the monthly contribution arising from the employment shall cease at the end of the month of contingency and during such months that he is not receiving wages or salary. Ibig sabihin, kapag ang employee namatay o na-disabled o umalis sa company, yung employer ang magbabayad ng monthly contribution sa buwan mismo ng end of the month kung saan hindi siya nakatanggap within the month. Article 190. Government Guarantee. The Republic of the Philippines guarantees the benefits prescribed under this title and accept general responsibility for the solvency of the state insurance fund. In case of any deficiency, the same shall be covered by supplemental appropriations from the national government. Ibig sabihin, sa Pilipinas, bali ang nasusunod naman ng gantong patakaran, then under yung State Insurance Fund ang pag-solve ng conflicts or may responsibilidad pagdating sa contributions. Also, in case na may kakulangan or problema, may nakalaan ang national government na funds.
Chapter 5 Medical Benefits. Article 191 Medical Service. Immediately after an employee contracts sickness or sustains an injury, he shall be provided by the system during the subsequent period of his disability with such medical service and appliances as the nature of his sickness or injury and progress of his recovery may require, subject to the expense limitation prescribed with the Commission. Ang isang employer o company ay kinakailangang mag-provide o magbigay ng isang medical service o kagamitan para sa agarang paggaling ng sakit o natamong injury ng empleyado at kasabay nito ang pagbabayad din ng bill or expenses nito. Article 192 Liability. The system shall have the authority to choose or order a change of physician, hospital, or rehabilitation facility for the employee and shall not be liable for compensation for any aggravation of the employee's injury or sickness resulting from unauthorized changes by the employee of medical service, appliances, supplies, hospitals, rehabilitation facilities, or physician. Article 186 means na ang isang company o employer ay may karapatang pumili o magdesisyon kung saan niya dadalhin o gustong ipagamot ang kanyang empleyado at wala silang anumang pananagutan dito kapag ito ay nagbago ng kanyang medical service nang walang pahintulot ng employer nito. Article 193 Attending Physician. Any physician attending an injured or sick employee shall comply with all the regulation of the system and submit reports in prescribed forms at such time as may be required concerning his condition or treatment. All medical information relevant to the particular injury or sickness shall, on demand, be made available to the employee or the system. No information developed in the connection with the treatment or examination for which compensation is sought shall be considered as privileged communication. Ang isang empleyado na under ng medication ay kinakailangan na magsumite ang doktor nito ng isang report upang malaman ang kanyang kasalukuyang kondisyon or ang kanyang paggagamot. Sa reports na ilalabas Nakalakip dito ang impormasyon patungkol sa kanyang natamong injury o ano ang naging sakit nito. Article 194, refusal of examination or treatment. If the employee unreasonably refuses to submit to medical examination or treatment, the system shall stop the payment of further compensation during such time as such refusal continues. What constitutes an unreasonable refusal shall be determined by the system, which may, on its own initiative, determine the necessity, character, and sufficiency of any medical services furnished. Kapag ang isang empleyado ay hindi nag-submit na medical examination or treatment, the employer or the company may stop the medical finances for their employee. Article 195, fees and other charges. All fees and other charges for hospital services, medical care, and appliances, including professional fees, shall not be higher than those prevailing in wards of hospitals. For familiar services to injured or sick persons in general and shall be subject to the regulations of the Commission, the professional fee shall only be appreciably higher than those prescribed under Republic Act numbered 6111 as amended, otherwise known as the Philippine Medical Care Act of 1961. Ang article na ito ay tumutukoy sa naging bayarin o gastos na empleyado ng hospital. Ang employer ay dapat magbayad ng hindi lalagpas sa idineklarang hospital bill at ang doktor na umasiwa dito ay kailangang bayaran ng hindi lalagpas na pagkasundo ang presyo under Republic Act number 6100. Article 196, Rehabilitation Service. A. The system shall, as soon as practicable, establish a continuing program for the rehabilitation of injured and handicapped employee who shall be entitled to rehabilitation service, which shall consist of medical, surgical, or hospital treatment, including appliances if they have been handicapped by the injury to help them become physically independent. B. As soon as practicable, the system shall establish centers equipped and staffed to provide a balanced program of remedial treatment, vocational assessment, and preparation designed to meet the individual needs of each handicapped employee to restore him to suitable employment, including assistance as may be within its resources, to help each rehabilitee to develop his mental, vocational, or social potential. Chapter 6, Disability Benefits. Article 197, Temporary Total Disability. Such regulation as the Commission may approve any employee under this title who sustain an injury or contract sickness resulting in temporary total disability shall, for each day of such disability or fraction thereof, be paid by the system an income benefit equivalent to 90% of his average daily salary, subject to the following condition: the daily income benefit shall not be less than 10 pesos nor more than 90 pesos, nor paid for a period longer than 120 days. B. The permanent for such income benefit shall be in accordance with the regulation of Commission as amended by Section 19 Presidential Decree number 850. Lahat na empleyado na nagtamo ng injury o nagkasakit ay kinakailangan bayaran ng katumbas ng 90% na kanilang arawang sahod. Article 198, Permanent Total Disability. A. Under such regulation as the Commission may approve, an employee under this title who contracts sickness or sustains any injury resulting in his permanent total disability shall, for each month until his death, be paid by the system during such a disability and plus 10% thereof for each dependent child, but not exceeding 5, beginning with the youngest and without substitution. B. The monthly income benefit shall be guaranteed for 5 years and shall be suspended if the employee is gainfully employed or recovers from his permanent total disability or fails to present himself for examination at least once a year upon by the system except as otherwise provided for in other laws, decrees, other orders, or letters of instruction. C. The following disabilities shall be deemed total and permanent. Number 1, temporary total disability lasting continuously for more than 120 days, except as otherwise provided for in the rules. Number 2, complete loss of sight of both eyes. Number 3, loss of 2 limbs at or above the ankle or wrist. Number 4, permanent total or complete paralysis of 2 limbs. 5, brain injury resulting in incurable imbecility or insanity. And 6, such cases as determined by the medical director of the system and approved by the commission. Letter D. The number of months of paid coverage shall be defined and approximated by a formula to be approved by the commission. Article 199. Permanent partial disability. Under such regulation as the commission may approve, any employee under this title who contracts sickness or sustains an injury resulting in permanent partial disability shall, for each month not exceeding the period designated, herein be paid by the system during such a disability an income benefit for permanent total disability. Letter B. The benefit shall be paid for not more than the period designated in the following schedules: complete and permanent number of months. Loss of the use of one thumb, 10 months, 1 index finger, 8 months, 1 middle finger, 6 months, 1 ring finger, 5 months, 1 little finger, 3 months, 1 big toe, 6 months, 1 toe, 3 months, 1 arm, 50 months, 1 hand, 39 months, 1 foot, 31 months, 1 leg, 46 months, 1 ear, 10 months, both ears, 20 months. Hearing of 1 ear, 10 months, hearing of both ears, 50 months. Sight of 1 eye is 25 months. Letter C. A loss of a wrist shall be considered as a loss of the hand, and a loss of an elbow shall be considered as a loss of the arm. A loss of an ankle shall be considered as a loss of a foot, and a loss of a knee shall be considered as a loss of the leg. A loss of more than one joint shall be considered as a loss of one half of whole finger or toe, provided that such a loss shall be either the functional loss of a use or physical loss of the member. D. In case of permanent partial disability less than the total loss of the member specified in the preceding paragraph, the same monthly income benefit shall be paid for a portion of the period established for the total loss of the member, in accordance with the proportion that the partial loss bears to the total loss. If the result is decimal fraction, the same shall be rounded off to the next higher integer. Letter E. In case of simultaneous loss of more than one member or part thereof as specified in this article, the same monthly income benefit shall be paid for a period of equivalent to the sum of the periods established for the loss of the member or part thereof. If the result is a decimal fraction, the same shall be rounded off to the next higher integer. Letter F. In case of injuries or illness resulting in a permanent partial disability not listed in the preceding schedule, the benefit shall be an income benefit equivalent to the percentage of permanent loss of the capacity to work. Letter G. Under such regulation as the Commission may approve, the income benefit payable in case of permanent partial disability may be paid in monthly pension or in lump sum if the period covered does not exceed 1 year.
Chapter 7. Death Benefits. Article 200. Death. Under such regulation as the Commission may approve, the system shall pay to the primary beneficiaries upon the death of the covered employee who is under this permanent total disability under this title 80% of the monthly income benefit and his dependents to the pension. This article, the death benefit under paragraph is the same in amount as the benefits of the permanent total disability or for permanent partial disability. It is an amount equivalent to his monthly income benefit plus 10% thereof for each dependent child. Chapter 8, Provisions Common to Income Benefits. Article 201, Relationship and Dependency. All questions of relationship and dependency shall be determined as of the time of death. This article enumerates the person considered as dependents. The test of dependency is not whether the claimants could support life without contributions, but whether they depend on such contributions as part of their income of means of living. Article 202, Delinquent Contributions. An employer who is delinquent in his contribution shall be liable to the system for the benefits which may have been paid by the system to his employees or their dependents, and any benefit and expenses to which such employer is liable shall constitute on all his property, real or personal, which is hereby declared to be preferred to any credit except taxes. This article, the payment by the employer of the lump sum equivalence of such liability shall absolve him from the payment of the delinquent contribution and penalty thereof with the respect for the employee concerned. Article 203, Second Injuries. If any employee under permanent partial disability suffers another injury which results in a recompensable disability greater than the previous injury, this article, the State Insurance Fund shall be liable for the income benefit of the new disability, provided that if the new disability is related to the previous disability, the system shall be liable only for the difference in income benefits. Article 204, Assignment of Benefits. No claim for compensation under this title is transferable or liable to tax, attachment and garnishment, levy or seizure by under any illegal process whatsoever, either before or after receipt by the person or persons entitled to it, except to pay any debt of employee to the system. The purpose of assignment of benefit is an agreement that effectively allows a third party to deal directly with your insurance carrier on your behalf. This means they can file insurance claim, make repair decisions, and even collect money without you having to lift a finger. Article 205, Earned Benefits. Income benefits shall, with respect to any period of disability, be payable in accordance with this title to an employee who is entitled to receive wages, salaries, or allowance for holidays, vacation, or sick leaves, and any award to benefit under a collective bargaining or other agreement. This article, the purpose of employee benefit is to increase the economic security of staff members and in doing so improve worker retention across the organization. As such, this one a component reward management.
So Article 206, Safety Devices. In case of employee's injury or death was due to the failure of the employer, comply with any law or to install and maintain safety devices or take other precaution for the prevention of injury. So this means po, if the employer injured or employees injured on the job due to their employer lack of safety equipment or hazardous work environment, so the employees po is eligible for ongoing wage replacement or can apply for death benefits. Article 207, Prospective Period. No claim for compensation shall be given due course unless said claim is filed with the system within 3 years from time of action accrued. So it means po that the employee's perspective in the exploded view consider working in the company or the employee's contribution to the company's success. So Article 208, erroneous payment. If the system in good faith pays income benefits to a dependent who is inferior to right to another dependent, or with whom another dependent is entitled to share such as payment. So, it is an payment would not have been made but for the failure by the employer. So, which is caused by intentional or advertent error by recipient. So, Article 209 prohibition, no agent, attorney, or other person pursuing or in charge of any preparation or filing of any claim for benefits under this title demand or charge for his service any fee. So, prohibited employee shall not include any employee who had not been employed by the company within 6 months. So, Article 210, exemption from levy tax and etc. Allows to the contrary, notwithstanding the state insurance fund and all its assets exempt from any tax fee, charge, levy, or customs or import duty, and no law enacted shall apply to state insurance fund. So this means po that the tax exemption is reduction or removal of a liability to make compulsory payment that would otherwise be imposed by ruling power upon person, property, income, or transaction.
Article 211, exemption from levy, tax, etc. All laws to the contrary, notwithstanding the state insurance fund and all its assets shall be exempt from any tax, fee, charge, levy, or customs, or import duty, and no law herein enacted shall be applied to the state insurance fund unless it is provided therein that the same is applicable by expressly stating its name. Chapter 8, Records, Reports, and Penal Provision. Article 12, Records of Death and Disability. All employers shall keep a logbook to record chronologically the sickness, injury, or death of their employees, setting forth therein their names, dates, and place of the contingency, nature of the contingency, and absences. Entries in the logbook shall be made within 5 days from notice or knowledge of occurrence of the contingency. Within 5 days after entry in the logbook, the employer shall report to the system only those contingency they deem to be work connected. B. All entries in the employer's logbook shall be made by the employer or any of the authorized official. Other verification of the contingencies of or employees' absence for a period of a day or more. Upon request by the system, the employee shall furnish the necessary certificate regarding information about any contingency appearing in the logbook, citing the entry number, page number, and date. Such logbook shall be made available for inspection to the duly authorized representative of the system. Letter C. Should any employer fail to record in the logbook an actual sickness, injury, or death of any of his employees within the period prescribed herein, give false information or withholds materials, information already in his possession, he shall be held liable for 50% of the lump sum equivalent of the income benefit to which the employee may be found to be entitled, the payment of which shall accrue to the state insurance fund. Letter D. In case of payment of benefits for any claim which is later determined to be fraudulent and the employer is found to be party to the fraud, such employer shall reimburse the system the full amount of the compensation paid. Article 13. Notice of sickness, injuries, or death. Notice of sickness, injuries, or death shall be given to the employer by the employee or by his dependents or anybody on his behalf within 5 days from the occurrence of the contingency. No notice to the employer shall be required if the contingency is known to the employer or his agent or representatives. Article 14. Penal Provision. A. The penal provisions of Republic Act Number 1161 as amended and Commonwealth Act Number 186 as amended with regard to the funds as are thereunder being paid to, collected or disbursed by the system shall be applicable to the collection, administration, and disbursement of funds under this title. The penal provision and coverage shall also be applicable. Letter B. Any person who, for the purpose of securing entitlement to any benefit or payment under this title, or the issuance of any certificate or documents for any purpose connected with this title, whether for him or for some other person, commits fraud, collusion, falsification, misrepresentation or facts, or any other kinds of anomaly, shall be punished with a fine or not less than 500 pesos, no more than 5,000 pesos, and an imprisonment for not less than 6 months nor more than 1 year. Letter C. If the act penalized by this article is committed by any person who has been or is employed by the commission or system, or a recidivist, the imprisonment shall not be less than 1 year. If committed by the lawyer, physician, or other professional, he shall, in addition to the penalty prescribed herein, be disqualified from the practice of his profession, and if committed by any official, employee, or personnel of the commission system or any government agency, he shall, in addition to the penalty prescribed herein, be dismissed with prejudice to reemployment in the government service.
Article 215 Applicability. This title shall apply only to injury, sickness, disability, or death occurring on or after January 1, 1975.
Title 3. Medicare.
Article 216 Medical Care.
The Philippine Medical Care Plan shall be implemented as provided under Republic Act numbered 6111 as amended. Title 4. Adult Education. Article 210. Adult Education. Every employer shall render assistance in the establishment and operation of adult education programs for their workers and employees as prescribed by regulation jointly approved by the Department of Labor and Employment and the Department of Education, Culture, and Sports.